it was mentioned by the court that even after the guilt is established, in a case where the section 360 of CRPC or section 4 of Probation of Offenders Act are invoked, uh, there are two paths for the judge to follow: either pass a sentence on him or invoke 360 and release him on probation. So it is a discretion of the judge to choose between these two options. Here, the court observed that while exercising the discretionary power, the court has to apply mind to the social background and personal factors of the crime doer. This area was observed to be a sensitive exercise of discretion, and the direct sentencing should not be done in a mechanical manner because that affects a personal liberty of a person. If he is supposed to be released under probation, this will severely affect his liberty. But unfortunately, the lower courts have disregarded the importance of these provisions. It was mentioned that even when section 360 is not attracted, it is a duty of the sentencing court to collect enough data regarding such facts, and the court has to make sure that such factors should have a bearing on the punishment. That is, a rehabilitating approach has to be taken as far as possible. So in the present case, here there was insufficient materials before the court regarding these factors. uh, the court pointed out that the courts are considering the legislation which ameliorate the punishments are considered to be minor acts generally by the lower courts, and therefore of little consequence it has. But on the contrary, such legislations actually have the same legal sanctity as that of other statute like major acts like CRPC, IPC, etc. So in the present case, the court considered his age, antecedents, and found that he is having a stabilized life. Also, the report of the probation officer was considered under section 4, and hence the court invoked section 4 clause 1 of the Probation of Offenders Act and released that person. So this verdict is based on the foundation of reformative theory of punishment. We know that our state is a welfare state, and judiciary is also part and parcel of state, which is relating to administration of justice. So in this judgment, it was implied that the courts also should try to be more inclined towards such an approach, subject to the legal provisions by which its powers are circumscribed. But uh, on the contrary, a deterrent or retributive approach, even though it has applicability to some extent, shouldn't be adopted as a general policy of courts. So I think this principle was implied in this judgment, sir.
So, just before starting, I would like to say that the very objective of punishment is evolving in the present social, economical, and political scenario in this country. And as receivers of this uh, and torchbearers of this change, we must be acquainted with some of the basic principles with regard to this. To start with, I would like to state that the propounder of the utilitarian theory, Jeremy Bentham, once said that punishment is always an evil, but it is always good to counter a much more evil. And Bentham's a student, Lord Macaulay was Bentham's student, and he has said that while drafting of IPC, he has said that the principle of suppressing crime with the smallest possible amount of suffering is what IPC is meant to be. That was his contention. Now, Chief Justice Warren wrote in Truth versus Dulles that the court must draw its meaning from the evolving standards of a maturing society. The great answer to grave crime is the culturing of higher consciousness, removing the pressure of a perverted social order, and nourishing the inner awareness of man's true nature. This is true penal reform including the jail reforms. And there was another case, that is Sunil Batra versus Delhi administration, and another, which is also a case rendered by Justice V.R. Krishnaiyer. And he has said that, in his judgment, he has said that punishments in civil societies must not degrade human dignity or wound flesh and spirit. The cardinal sentencing goal is correctional, changing the consciousness of the criminal to ensure social defense. Where prison treatment abandons the reformatory purpose and practices dehumanizing techniques, it is wasteful, counterproductive, and irrational, hovering on the hostile brink of unreasonableness. The torture tactics used will not jump the constitutional gauntlet by wearing a preventive purpose. Naturally, inhumanity masked as security is outlawed beyond backdoor entry because what it is banned is brutality, be its necessity punitive or prophylact, prophylu, prophylactic. So, this is what V.R. Krishnaiya's views was about when it came to the sentencing policy while discussing uh, punishments. In this present case, also, he reiterated the same. Uh, the earlier case, as I mentioned, that is Sunil Batra case, was just before this case, and Ved Prakash in this case, he enunciated that aspect here. More importance was given to Article 19, and the bench of V.R. Krishnaiyer as well as E.S. Venkatramaya in this present case has noted that he be released on probation and with certain conditions. His father was made one of the persons executing the bond. More leverage was given. Some observations also made regarding the trial court as being functionary in discharging its sentencing functions, etc. Now, I would like to state two more points in this regard. One is the recommendation of a committee on reforms of criminal justice system of Ministry of Home Affairs of 2003, in which the paragraph 14, clause 10.2 states that the Law Commission, in its 142nd report, stated that it is desirable to infuse life into reformative provisions embodied in Section 360 CRPC and the Probation of Offenders Act, which, according to the Law Commission, remain unutilized. Law Commission noted the disadvantages of plea bargaining, which ensures speedy trial with benefits such as uncertainty, saving of cost of litigation, relieving of the anxiety that a prolonged trial might involve, and avoiding legal expenses. The Law Commission also noted that it would enable the accused to start a fresh life after undergoing a lesser sentence. Law Commission noted that about 75% of total convictions are the result of plea bargaining in USA, and they contrasted it with 75% of the acquittals in India. Law Commission also observed that certainly plea bargaining is a viable alternative to be explored to deal with huge arrears of criminal cases. The same might involve pre-trial negotiations, and whether it is charge bargaining or sentence bargaining, it results in a reduced sentence and early disposal. Lastly, I would like to quote a judgment of the Supreme Court in State through CBI Anti-Corruption Branch Chandigarh versus Sanjeev Bhalla and another, which was a decision rendered by R.K. Desai and Madan B. Lokur in July 4, 2014, uh, in which it is stated in sentence 21, to sum up, for awarding a just sentence, the trial judge must consider the provisions of the Probationers of Offenders Act and the provisions of probation in Criminal Procedure Code. And B, when it is not possible to release a convict on probation, the trial judge must record his or her reasons. So I believe from what I have said and what I have heard in this present case, it is imperative for the courts to first consider.
ആ കേസ് ഒന്ന് വാട്സപ്പിൽ ഇട്ടേക്കോ?
ഇടാം സർ, ഇടാം.
Okay, you continue this. Yes.
Sir. So, from what I have said and discussed in this matter and heard, it is imperative on the courts at hand to first consider to release the person by seeing his criminal antecedents and various other factors, which with more importance the social background of the person too, and personal liberty as envisaged in Article 21 must be given penultimate importance, and that should be the guiding factor and light, and court should not be the dictators of colonial laws as it was in its traditional sense. It should be much more uh, reasonable. It should be much more flexible when it comes to infusing into the society. This is what I personally felt in this matter, sir.